Good afternoon, everybody. Jeff Jenkins and Eric Clayman here again for another episode of our Facebook Live series. And today we're going to be talking about some of the moratoriums that exist. And we've gone over that again and again before. But we also want to explain in some detail the foreclosure process in New Jersey, as well as the eviction process by a landlord, so that you can understand how it's important that at certain points in this process, if you want to stay where you are, you need probably to see an attorney. And like Eric is fond of saying, and he reminded me to say it today, they have attorneys, and you need an attorney too. So the moratoriums, you know that game Whack-A-Mole where the things pop up and you get them? Yeah. So that's what this whole thing has been like, about trying to figure out what's going on today, because it'll change tomorrow with the moratoriums on evictions and foreclosures, sheriff sales. I see that we just had not a decision, but the Supreme Court declined to hear that case about the CDC pushing the eviction moratorium back to the end of July. And I think Justice Kavanaugh, in an insightful few words, said that he didn't agree with it, but it's only a month. You know, what the heck?
That's why you went to law school.
Right, I guess. So in New Jersey, now and in the past, we've not cared that much about what the CDC is doing. I think it's illegal for what it's worth, but we've focused more on what's going on in our state with our governor and what he's decided to do and what the legislature may have decided to do, because it seems that their actions have gone beyond what we're getting from the federal government. So if we're talking about a moratorium, the federal government's going to leave it on for another 30 days, but in New Jersey, it's staying till the end of the year. So the moratorium on evictions is New Year's, right? December 31st or the 1st of January, 2022, whatever you want to say. Unless I don't know if the governor signed that legislation yet, but it passed the state legislature last week. And they did want to have the eviction moratorium go until the end of the year, unless you make 80% or more of the median income for a family your size in your area in New Jersey.
And that's easy because everyone knows what the median income is for their family size in their area of New Jersey. That's an easy solution, isn't it?
Yeah.
Very practical.
Yeah, and then you've got to attest that you were affected adversely financially by COVID, and that you've tried to participate in any rent programs that would give you money for your rent, either you or your landlord.
Well, let's talk about this a little bit, Jeff, okay? Because it is confusing. First of all, the word eviction is, the way Jeff and I use it, is a very specific term. It actually means that you are being thrown out of your house. That's what we mean by eviction.
Yeah.
And that's what we mean when Jeff said that's not going to happen until the first of the year. And there's all sorts of winter rules involved as well. So whether it will happen the first of the year,
for certain families, based on their income, their heat source can't be shut off, whether that's electricity or gas.
So there's all sorts of things. But let's say that's the 1st of January, and that's an actual thrown out of the house. However, you lose certain rights once the judge enters a judgment or a warrant for possession or a final judgment on the landlord-tenant action. So let's talk about that a little bit. If your landlord claims you are behind and files a lawsuit against you, you're served with this lawsuit. And as of real soon, they're going to put a date on that lawsuit for a hearing.
I think so. I mean, they started I think we said this last time, June 2nd, landlord-tenant court opened up as far as commercial properties and vacant properties are concerned. And there was an indication that they felt that they would probably be opening up landlord-tenant court for residential matters in the late summer, whatever that means.
So carrying that forward.
Maybe the Ides of August.
I think is August the blue moon month? Maybe.
I don't know.
What that means. So if you're served with a summons and complaint in an eviction action and there's a court hearing date, that's the date you need to retain an attorney before that date. Or you need to plan on going to court yourself, or you need to do something. And just to sit there and say, well, I can't be evicted until the end of the year because I heard Jeff and Eric say that. That's not what we're saying. And what we're saying is you lose a lot of legal rights on that date of the landlord-tenant complaint. And if you receive a summons and complaint that has a date, you should call us at this phone number below, because just as Jeff said, if your landlord's hired a lawyer, or as if your landlord has decided to go to court, you need a lawyer to go to court. And we won't go to landlord-tenant court for you, but what we will do is stop the complaint. And it has to be stopped then, because if they get a judgment on that date, many, many legal rights which you have under New Jersey's law and bankruptcy code, for that matter, just go away.
Exactly. Yeah. If you, just to kind of, Eric's been talking about it, but to go over the landlord-tenant process, there have been complaints going out, but they haven't had dates on them. So you're not really getting a summons to appear on a certain date because the Supreme Court shut down landlord-tenant court. But like Eric said, they should be shortly giving you dates. And if you get a date and you don't do anything, what's going to happen is the state court judge is going to sign a judgment for possession in favor of the landlord. And the landlord has to wait 3 days, and then he can get a writ of execution on that order. He'll give that to the sergeant at arms of the court, and the sergeant at arms within a week or so will come out to your residence,
to your front door,
and put a note on your front door that if you're not out in 10 days, he's going to come back and evict you, throw you out. The bankruptcy code says that its protections, as far as tenants are concerned, stops once there's a judgment for possession. If there's a judgment for possession and then you come and see us, there's nothing that we can do for you with the bankruptcy code.
Well, there's nothing we can do as far as stopping the eviction from continuing. What we can do,
I guess I misspoke.
I just want to make that clear, is that if you've decided to move anyway and you can't afford to pay your landlord when you're living there, you don't want to pay your landlord when you're not living there. So we've had many, many happy clients see us after the eviction judgment, after they move, while they're moving, and they pay us to do a Chapter 7 bankruptcy, most likely. And it wipes out the landlord. The landlord gets nothing. So Jeff's correct, of course. If you see us after the date of the judgment for possession, we can't prolong you living in the property. We can't develop a plan. But you can still see us to get rid of that debt. And the debt can be significant.
It sure can. I mean, you could be behind right now a year. I mean, we were told to stay in our homes more than a year ago, a year and a quarter ago. And I never would have believed we'd be sitting here today, although it seems that we're seeing the light at the end of the tunnel, but we still have this stuff going on.
So I interrupted you. You were talking about the fact that let's keep talking. So if there is a judgment, and then as you said, the constable or the sergeant at arms will post it on the door, and 7-10 days later, they're going to throw you out. Now that's the part that it appears as if the governor is stopping until the first of the year.
That's correct. So once the Supreme Court opens up landlord-tenant court for residential matters, then those things that we were just talking about, and that is the judge signing an order for possession in favor of the landlord getting a writ of execution, that being given to the sergeant at arms of the court, and the sergeant at arms going out to your residence and putting a little sign on your door. All those things can happen then. It's just that You
He's
can't
not
be
gonna put
evicted.
he's not gonna put this
Yeah.
up.
I mean, at some point, maybe there will be no writs of eviction. Maybe just getting the judgment for possession. But once they have that judgment for possession, we can't keep you in your property by filing a bankruptcy.
That's
So
exactly right.
this court stuff, these things can happen, but you can't get thrown out of your property until the end of the year,
Right. And
basically.
and it's just a question about whether you want to stay there longer. I always tell clients, I don't know what your living arrangement is. For me, if I lived next to a house with 3 Doberman pinschers that barked all night, I'd be thrilled to be thrown out of my house. Jeff likes dogs. Maybe he would like that. So there's often non-monetary reasons why you want to move out or not move out.
Mhm.
But if your kid is the starting quarterback for the football team and you want to live in that the school district and you want to stay there, then we're going to bend over backwards to help you with one caveat. See us before the landlord-tenant hearing date, and we'll keep you in that property for a long time. If there's any more questions about that, we're going to go into foreclosure shortly. I recommend that you give us a call and ask for Jeff's book. You see the phone numbers on the bottom, 856-546-9696, and tell them you want a copy of Jeff's book, Make Bankruptcy Work for You. There's, I think, 2 chapters, if I recall, on this landlord-tenant matter, and you can take a look. Now, of course, COVID's made things a little bit more difficult to predict. As Jeff said, it's like, what do you call that?
Whack-a-mole.
Whack-a-mole. But this book's a real good start for you to learn what we can do to help you and also to learn other legal rights you may have. So give us a call, ask for Jeff's book. It's free. The phone call's free, no obligation. And we can help you. But I'm trying to transition, Jeff, because this is the best 20 minutes on the internet. We're already 12 minutes in.
Right.
Let's talk a little bit about people who own their home and, as you said, have been locked in their home for months, just getting out now.
I think we've been released. I think
Yeah,
at some point the government released us from our homes.
that was very nice.
Very kind.
But people are behind with their mortgages in this area, which is a very serious, stressful situation.
Absolutely, and the numbers are significant throughout the country. It's just the people that are delinquent on their mortgages is astronomical. The number of people, and we'll go over the foreclosure process just a little bit.
I think it's important for people to understand because the process has been slowed by the COVID pandemic and the related laws, but the process is still the process.
Right, it is.
Which typically I'll start and you can fill in, Jeff. But basically, if the mortgage company believes you're behind, they send notices. They have to comply with the Fair Debt Collection Practices Act, and then eventually they will hire a lawyer to file, or a law firm to file a summons and complaint in foreclosure. And that's when the legal process starts to change the ownership of the home from you, the homeowner, to the mortgage company as the lien holder. They seek to enforce their lien and foreclose. Jeff, it's not a pleasant situation when you're behind with the mortgage. There's a lot of stress, and that at that point they've hired a lawyer. So what should you do?
Hire a lawyer.
Yeah, you have to.
Yeah. It's not pleasant to have the sheriff knock on your door and serve you with one of these things. It's kind of scary, really, but that's what's going to happen with foreclosure. You're going to get served with a summons and a complaint, and there may be times when you could contest the foreclosure, but that's very, very seldom. You can certainly file an answer, but if the answer doesn't go to the matter at hand, the court's just going to ignore it, basically, and allow the foreclosure to proceed. You'd have to have the answer would have to be something like you're contesting the validity of the note mortgage or the amount of money that they're contending you owe or whatever. So assuming that you don't contest anything, then they're going to end up getting a default judgment in state court based on their complaint that they filed. And once they have their default judgment, they do need a writ of execution similar to landlord-tenant court. And those writs have a a certain lifetime. It's 2 years. They can last for 2 years, and then if they haven't gotten the property to sheriff's sale, they have to get a new writ. That's maybe not necessary to talk about, but anyway, they're going to go to the sheriff with this writ of execution, and that's the document from the court that tells the sheriff to sell this property at a sheriff's sale. And the sheriff has to advertise the property for sale at least 30 days before the sale happens. A lot of them have websites with postings on there about sheriff sales. Some of them advertise in local papers.
If you know what a newspaper is, yeah.
Yeah, right. And so if nothing is done, you don't do anything to interrupt that whole process, eventually there's going to come the sheriff's sale day. And on the sheriff's sale day, the sheriff is going to, as part of the proceedings, name that property, your property, and people can bid on the property. Normally, like Eric was saying, you usually see the mortgage company being the only one that opens their mouth. But if the home has some equity in it, you might see third parties bid on it as well. And so the attorneys representing the mortgage company are generally going to start off with a bid of $100. And they'll have a figure from their client, from the mortgage company, to the penny what's owed that day. And if somebody else starts bidding, they'll bid with them until they get to that number about exactly what's owed today. And if the other party is willing to go higher than that, then the mortgage company is going to drop out and the other person will get the property, a third party. The mortgage lien is still there. It still has to be dealt with. And by buying the property, this third party would give the sheriff money, and the mortgage company would end up being made whole monetarily by the sheriff.
But Jeff, we're bankruptcy lawyers, so let's talk about what we can do.
Okay,
one more point, sure.
Yeah, one point. If once that happens, the sheriff's sale occurs, the sheriff, according to our state law, has to wait at least 10 days before they deliver a deed to the property to the successful bidder. And a lot of people think this is like a right of redemption period. It's not. It's really a period of time for you to contest the foreclosure matter if you have any problems with it. But the point is that the property is still yours even after the sheriff's sale for at least 10 days, because the sheriff has to wait the 10 days before he delivers the deed. And we're going to talk about, just like we did with the landlord-tenant situation, where we get to the point where we can't, our options are really severely limited in terms of a bankruptcy.
Exactly. That's what while I was interrupting you to say. And now, thank you for the introduction. Unlike, and it's not surprising, if you think about it, if you were a lawmaker, who would you give more protection to? A tenant or a landowner? And they're giving the courts, the Congress, federal courts, our state legislature, all gives more protection to the homeowner, the landowner. And remember what we told you in landlord-tenant court, once there's a judgment of possession, there's very little we can do except get rid of the debt. However, on a homeowner situation, judgment is entered, a foreclosure judgment. As Jeff said, there's a sheriff's sale scheduled. We can file bankruptcy. Two things, but number one, we can file bankruptcy right up until the sheriff's sale date, and we can do a normal Chapter 13 plan for you to repay the debt, and you will save your home. That's easy. And even if you got caught up in other things and you don't see us until after the sheriff's sale, but during that 10-day, it's called often referred to as redemption period, during that 10-day period, we can file bankruptcy for you then as well. And that extends that 10-day period to 60 days. And we could try to work on a refinance for you, something so that you can keep your home.
A loan modification. The property would be yours. You could sell it, for example.
Right. There's all sorts of things we can do. So landlord-tenant, see us before the court hearing date. if you're a homeowner, see us. Even if you think you've waited too long, let us tell you you waited too long. Don't you make that decision. I have that same comment, Jeff. When people see us to file bankruptcy, they say, well, I didn't bring in that bill because I didn't think you could help me with that. Don't say that. When you see us, bring in all your bills or email them to us or fax them to us, because we are still seeing clients from the comfort and safety of their own home and in here as well.
Right.
So however you get us the bills, get us all the bills, and let Jeff tell you, no, we don't include that bill. But don't make the mistake of being your own lawyer and saying, I can't file bankruptcy. There's already been a sheriff's sale. I can't. Because we're all about, you can save your home.
With the mortgage situation and the arrears that have accumulated, they're substantial too, just like a lot of rent arrears are. People might have not made a payment since the middle of March of last year. And so we're talking about 1.25 years worth of mortgage payments, and that certainly adds up. Even though you may have entered into a forbearance agreement with the mortgage company, what they have to do that for you. They have to offer that. But if they proceed with a foreclosure, if they're allowed to in our state courts, and there's a sheriff's sale scheduled, they can do something for you, but they don't have to. I mean, if you say, well, why don't you take all my arrears and just put them on the end of the loan? And the federal government has told the governmental agencies that back mortgage loans, back about 70% of the mortgage loans, that they can do that, but have not told them they have to.
Right.
You can. They told the mortgage companies, you can take the arrears that exist and put them on the end of the loan. And there's a big difference here, not only in a mortgage situation, but also a rental situation, between missing payments during COVID and having pre-existing arrears when COVID started. Right. Because all these, the forbearance thing and all this other stuff, it applies to arrears that happened after COVID, after the middle of March of last year. Not if you were 3 or 4 months behind, there's nothing that's going to help you with that. The mortgage company could entertain an application by you to do a loan modification, perhaps, but they don't have to, and they don't have to do the loan modification. So, but if you come and see us, at least we can talk to you about these things. And one thing that the legislation surrounding COVID-19 has done is it's increased our options as bankruptcy attorneys. Right. to help you with a larger than normal amount of arrears, whether we're talking about rent or mortgages. As long as if you file a bankruptcy before the end of this year, 2021, we can do a plan for you that can last up to 7 years, 84 months. Normally, according to the bankruptcy laws, we can't propose a repayment plan, a Chapter 13, for longer than 5 years. But with this legislation, we're given 2 extra years, which might make a real difference. You know, when you look at what it's going to do to your monthly payment, if you had to pay the mortgage arrears through the trustee, it makes a big difference. And we can absolutely, positively do that. They might not give you a loan modification. They might not put the payments on the end of the loan, but we can definitely file a bankruptcy and pay the arrears through the trustee, and we can take up to 7 years to do that.
Remember, the moment you file bankruptcy, you're protected. You can take that deep breath. No one is going to take your home from you, okay? And Jeff and I will tell you if you're at risk, what your risks are, and things like that. Knowledge is power. Talk to an attorney. Minimum, give us a call, ask for Jeff's book, read it over, call us back, and we'll help you. That's what we do all day, is help people who are often, due to no fault of their own, just unable to pay all their bills right now.
All day, every day for 35 years. So we probably know what we're doing. Guess. You okay for today?
I think that was a chock full, except for my one interruption of you, Jeff. It went very well.
It's okay. We both interrupt. That's all right. So I guess we'll wrap up for today, and plan on seeing you next Thursday at 2:00 with another topic Until then, stay safe and God bless.